All right. So we had some technical difficulties last week, so we will be doing chapters 5 and 6 this evening. Next week is the week of Thanksgiving. We will not be having class Tuesday as I will be away. So next week you will have off. We'll return the following week, December 3rd, and we will be covering chapters 7 and hopefully getting into chapter 8 as well. Those are a couple of longer chapters, so we'll get as far as we can get and then go from there. Tonight, chapter 5 is patient education. So we're going to discuss holistic model of patient education related to health and illness, summarize the stages of grief and how to interact with your grieving patients, 5 guidelines for patient education that can affect their overall wellness, do the following related to patient factors affect learning. So there's 6 patient factors that can have an impact on learning. Discuss respect for diversity, educational approaches for people with learning disabilities, determine barriers that can affect learning, what are your patient's needs, teaching priorities, appropriate teaching materials, ability to demonstrate appropriate and effective patient teaching plan, the role of an MA with regards to patient education, integrate legal and ethical elements of patient teaching. We'll also discuss HIPAA, Health Insurance Portability and Accountability Act. So if you look on page 54 is where we're going to start. It's the models of health and illness. And the keys to a successful health teaching is to empower the patients to accept responsibility for their own disease process and become willing to implement teaching guidelines to help them. Hopefully, by doing this, it will cut short average hospital stays, meaning patients and families must provide more care, greater responsibility to educate the patients and their family, use holistic approach to address their physical, psychological, social, and spiritual needs. And this is all on page 54. If you look down at the holistic approach, which I mentioned, you can see the psychological effect of the disease. So they're in denial or they're in shock, they're angry or depressed. How does their emotional reaction to the diagnosis affect their response to learning about their illness or disease? Social, cultural, how will family and employer respond to their demands of the diagnosis, meaning how will it affect their lifestyle, their work, that type of thing. Intellectual impact, are they able to understand the complexities of the disease and the treatment recommendations? Economic impact, can they afford the treatment? Do they have health insurance to cover it, or are they going to need some sort of assistance? Spiritual impact, what is their spiritual response? How might their spiritual beliefs, affect the compliance with treatment? So all of that plays a role in educating your patients. If you look up on page 55, the health belief model, perceived susceptibility, patient's opinion on the chances of developing the disorder. So how do we educate them? We give them information on the risk, the individual risk based on patient's health habits, family history, perceived severity, the patient's opinion on the seriousness of the condition. So we outline the complications of the disease, perceived benefits. They believe in the value of altering lifestyle factors and complying with treatment. So we emphasize the positive results that can be achieved if they stick with treatment and they comply. Perceived barriers, their opinions on the financial and psychological cost of compliance. So identify those barriers, work with them through patient education, outreach, community. Cues to action, methods developed to activate patient compliance. So do the one-on-one patient education. Handouts involve the family, friends, follow up at subsequent visits, and self-efficacy. Patient has confidence to take action to become healthier. And again, that's providing ongoing educational information and support. So the factors that affect their response is again going to be the emotional effect of the disease, the social impact, family and employer, intellectual impact, economic impact, and spiritual impact. If you take a look on page 55 in the second column, there are 5 stages of grief: denial and isolation, anger, bargaining, depression, and acceptance. So, denial is they're going to deny that they have the disease, they're not going to accept it, they're going to refuse to do anything. Anger, they may be very angry and hostile when discussing the condition. Bargaining, patient tries to bargain for privileges or time. Depression, patient grieves the loss of health, very sad about the diagnosis. They don't want to have to deal with the disease, they just want it to go away. Acceptance, the patient finally gets to the point where he or she accepts the diagnosis, they're ready to make the best of it and deal with it. So there are 5 stages that they're going to go through. And again, you can see at the bottom of 55, there's therapeutic interactions for grieving patients. So, what can we do as providers and medical assistants to help them through that process? On page 56, patient factors that affect learning. There's perception of disease versus the actual disease itself, the need for information, patient's age and developmental level, mental and emotional state, influence of multicultural and diversity factors on patient education, and patient learning style. So you can see on page 56, perception of disease versus actual state of disease. So they can react to it in many different ways. So how do we educate them on the disease to help them with this process? Do they recognize the seriousness of the diagnosis and what is involved? The need for the information. Obviously, we want to give them as much information as we can about the disease. Do they want to learn about the disease, or are they not interested in just going through the steps, so to speak? The vital part of patient education is encouraging patient ownership of the learning process for what they have. So we have to help them understand what is going on with that disease process. Their age and developmental level, of course, depending on their age, we may have to adapt that teaching plan, especially if they're a child. We have to rely on the parents' help in that situation. The patient's mental and emotional state, even a well-planned teaching process can be ineffective if the patient's unable to pay attention because they have stress or anxiety or anger. And again, the denial, the D word. So again, helping them be sensitive to the patient's mental state and adapt the teaching for that process. Influence of the multicultural and diversity factors. Again, these will all play into effect. So you work with patients with diverse backgrounds. That can be very challenging. However, for the education to be Um, Successful, we need to recognize and be sensitive of how everything impacts them. So we can, if language is an issue, if they're not able to understand English, then we need to bring in an interpreter. Um, Maybe if they can't speak English, but they can understand it and they can read it, we can use more of the paper format. Does their culture or ethnic background influence how they perceive the disease or the role that the healthcare worker has on that? So, what do we do for language barriers? Again, determine if they can read and or understand English. Address them by their name, courteous, formal approach, gestures, facial expressions. Integrate the handouts, models, drawings, visual aids, anything like that. Observe their body language, simple, everyday words if possible. You may even need to have, again, a dictionary or translator. Demonstrate the procedures if that is possible so they have a better understanding of what would be happening, and make the teaching process, do it in small steps, manageable small steps. Written instructions for all procedures, and again, the interpreter if at all possible. And if you can get patient educational information in their language, that would be a plus to be able to give them that as well. Everybody's got a different method of learning. So everybody's going to do it their way. So take time, make sure you understand the material beforehand before we bring it out and bring it on to the patient. Life experiences can influence patients' perception of the diagnosis. Again, do they recognize how serious this is? And how do they react to potential disease risks that they may have? The perception of impact of the disease on his or her general health also determines the need for how much information we need to provide them on the disease. So encourage that patient ownership of that learning process. Went over sensitivity of the patient, the language barriers, the learning style, impact of physical disabilities. So the patient first needs to be assessed to see if they can adequately hear, see, and that is going to affect how we teach as well. If they cannot see, obviously the visual aids and the handouts are not going to work. So we're going to need to address that. So if they have vision loss, alert the patient you're in the room, identify yourself. Um, Patient is unable to pick up your body language, so make sure you are speaking clearly and a normal tone of voice, and provide all written information in large font or print size in case they have some vision or are going to have somebody help them with that. If they have hearing loss, allow the patients to see your mouth so that if they can read lips, they have the availability to do that. You may need to touch your patient to gain attention. Use expanded speech. Observe body language for understanding or confusion on behalf of the patient. Use gestures. Demonstrate clearly. Again, print information needed for clarification. Provide those written handouts. And request family assistance if needed to verify that the patient's understood. The approaches for the language barrier, that teal colored table on page 57 is a great tool to help you with that information as well. So, how do we decide on the appropriate teaching methods? So, it's going to be individualized for your patient, and that is going to be key to understanding and patient compliance. Include a handout, some type of printed material reinforcing the information, and have it so that the patient always has access to it to use as a reference. Guidelines for educational supplies. Material should be written in a language, typically 6th to 8th grade level, they say. If the patient has a different language, if you can provide it in their language, that's a plus. Well organized, clearly described, all material, make sure it's accurate. Don't give out anything that has old information that may be updated currently. Um, make them as attractive as you can or professional looking. Copies should be available in other languages and again in large print for people that may have issues seeing. We need to identify the community resources that we have available. So help the patients and their families with continuing or community education and support, up to date on those area resources. So you always want to make sure that you have the most current information on those resources, because we don't want to give our providers information, our patients information that is not up to date, because that would not be good. They would be going the wrong place for information. You can see on page 59 how we identify those community resources. You can go through phone books, you can go through community centers, outreach programs, hospitals, anything like that to help you locate. And of course, Google, the internet is a big friend, so we can always find out information like that. On page 60, using DVDs, approved YouTube videos, if there are those that help describe what is going on. So the patient assistant as a patient navigator on page 60. So a patient navigator is somebody who helps the patients and their family with insurance problems, explaining the treatment and care, communicates with the healthcare team, assists caregivers, manages medical paperwork. Medical assistants are cross-trained in both administrative and clinical, so you have a unique position there to serve the patient, to serve as a patient navigator in an ambulatory care setting. Some patients prefer the administration side over the clinical side, and that's absolutely fine. It can be split, or you can choose to do both. On page 61, decide on appropriate teaching methods. So here, again, use your community resources to reinforce the message. Teach them the specific skills that they'll need with regards to their specific illness or disease. Have patient keep a journal of his or her activities and how they respond to treatment, so their side effects, how they felt, anything like that. And make sure that you are involving the family members in that patient's education as well. How do we implement the teaching plan on page 62? So after we complete the assessment, we need to decide how we're going to start the process. We want to do it in a quiet area where there's little or no distractions. Assemble the equipment that the patient will need. So we want to make sure all of that is ready before we bring the patient in to do that. Present only material or skill that it is possible for the patient to master before the end of the appointment. We don't want to overwhelm them. So again, doing it in like baby steps. Restate, repeat, rephrase the material Evaluate a teaching plan throughout the process. So as you go along, we'll be able to tell how much we can cover during that session with the patient. Again, we don't want to overwhelm them, so we want to maintain an adequate pace while we're teaching, not too fast. What are their immediate and long-term needs? This is on page 62 in the turquoise grid. Ask them for feedback. Do they understand? Do they have questions? Again, summarize, reiterate the material. Give them an outline for what's going to be covered at the next session. And evaluate that teaching plan before they come back to make sure we're going in the right direction. Document what you have gone over with them with the teaching process in the medical record, so that if it needs to be picked up by someone else, should you be out ill, they will be able to know where you stopped with the process and can pick it up and go from there. On we went over the using the patient interaction, which is a great opportunity for health teaching. Again, keep it relevant to the patient's needs. Get a good rapport with the patient. Make sure you're, again, communicating clearly. Be sensitive to their learning factors, and modify the teaching plan to make sure we are best fitting that patient's needs. If you look on page 64, in closing, the legal and ethical issues. All of your patients have right to information before they agree to receive care, so we want to make sure we are providing that information. Conduct adequate patient education and follow-up. Document that patient education intervention completely and accurately. That way there's no question of what you were teaching the patient and what the patient interpreted. Meet needs of all patients without evidence of prejudice. And again, this is real important because we don't want to have any issues down the road. We want to make sure that we are doing everything in the appropriate manner and that the patients are understanding what is going on, what's going to be done, how the treatment is going to affect them long term, short term. HIPAA applications, the patients have a right to restrict who can receive that personal health information, or PHI. Only the people or persons identified on the HIPAA release form, which has to be completed by the patient, have the rights to the patient's information. So the patient may not want you to discuss information with their spouse or children. And that needs to be well documented so that when you are doing your teaching, they may not want all family members involved, and you need to make sure we have that correct information so we don't involve those family members that they may not want. Contact the family only if it has given information. If you look on page 64, the last bullet, if the provider believes it's in the patient's best health interest that family members be involved in the education, the provider may ask you to contact the family and move forward from there. But again, we do have to acknowledge HIPAA and make sure we are honoring who the patient wants us to contact and not contact regarding their illness. So medical assistants are members of a profession in which information about diseases, treatment, diagnostic, health problems is constantly changing. So again, we need to make sure we are on top and always current on our information that we are letting patients, that we are explaining, and making sure that the printouts are always updated as the information can change frequently. So a lot of times you may not want to keep a lot of printouts on hand. you may just want to print them out prior to the patient coming in way, or the day before, so you can review it, but that way you've got the most current information that is available. So that is it for Chapter 5, Patient Education. We're going to move on to Chapter 6, which is Medicine and Law. This one is, again, it's medicine and law, so it's a lot of the legality stuff. So I do advise that you read through the chapter on your own so that you're aware of things that can arise and what the consequences may be. But we will touch on the information so that you are aware. Again, the beginning of every chapter is your vocabulary words, so be aware of those words. You will hear them often in your field of work. We'll talk about criminal and civil laws as they apply to medical assistant. We'll also talk about contract law, summarize anatomy of the medical professional liability lawsuit, and the 4 elements of a valid contract. What are the various parts of a medical professional liability lawsuit? Advantages of mediation and arbitration. Excuse me. Do the following related to medical liability and negligence. Differentiate malfeasance, misfeasance, nonfeasance, the 4 Ds of negligence, and types of damages. We'll talk a little bit on risk management and describe liability, malpractice, personal injury insurance, and the importance of informed consent. And we'll define statutes of limitations and confidentiality. This is all in the purple box on page 67. Compliance reporting, Patient Self-Determination Act, Uniform Anatomical Gift Act, and the Patient Bill of Rights. Important features of ADAA and the GINA Acts. Components of HIPAA, Health Insurance Portability and Accountability Act. Identify and talk about high tech, which has to do with the impact on electronic transmission of patient records, and summarize and talk about the Affordable Care Act. So again, a lot of it is probably more information than you need to know, but it's always good to be aware of it because the law is a fascinating subject. It's very detailed. Generally, the law holds every person liable for consequences for his or her own negligence, and they need to pay damages for those negligent acts. If you look on the bottom of 69, jurisprudence and classifications of law. So you'll see jurisprudence is a science and philosophy of law. It comes from the Latin word, which means law, right, equity, justice. And then the prudentia or prudence means skill or good judgment. So law is custom or practice of a community. The act, a law enacted at the federal level, which must be passed to Congress, is called an act. Statutes are laws that have been enacted by state legislation, and local governments create and enact what we call ordinances. Much of our law is based on previous judge and jury decisions, which are called precedents. If you look on page 69, we're going to talk about criminal law versus civil law. So if you look, criminal law governs violations of the law punishable as offenses against state or federal government. So this can be the welfare and safety of the public as a whole rather than individual. So a medical assistant can be prosecuted for criminal acts such as assault, battery, fraud, and abuse. There are 3 categories: misdemeanors, felonies, and treason. So, for fair treatment under the law, all individuals are entitled to what they call due process. So, a misdemeanor is a minor crime. So, this can include a fine, probation, community service, restitution, just to name a few. And a felony is a major crime: murder, rape, burglary. This can end with imprisonment for at least one or more years, and they can lose the right to vote, cannot be employed in certain professions, may not be allowed certain licenses such as handguns, firearms, that type of thing. Civil law is concerned with acts that are not criminal, but they involve relationships between individuals and other individuals, groups, or government agencies. So, again, your criminal law, punishable as offenses, state and federal government. Misdemeanor is the minor crimes. Felonies are the major crime. And treason is considered a felony as well. Now, the civil law, again, not criminal in nature, involves individuals, organizations, and government agencies. If you look on page 70, there's also something called the tort law, and this provides a remedy for a person or group that's been harmed by wrongful acts of others. So a defamation case would be judged under a tort law. There's 4 elements that need to be established, and medical professional liability or medical malpractice falls under this tort law. You can see here that libel is written, slander is oral. These are acts that fall under defamation. When a person is liable for an act, they will be obligated or responsible according to the law. And again, your medical malpractice or professional liability also falls under this category. So you, as a medical assistant, can invest if your provider doesn't take it out for you. You can invest in liability insurance to cover yourself should the need arise. Contract law, it's an agreement that creates an obligation. It touches our lives in many ways every day. Contract does not have to be formalized in writing to be binding for the parties involved. Oral contracts are binding in most states for most situations. So again, it doesn't have to always be written. This is why ambulatory care facilities require medical assistants to gather payment information before the appointment is scheduled. Doesn't have to involve a lot, but it is part of the contract, so to speak. Liability insurance and third-party insurance. So your provider needs to carry professional liability insurance, which is a type of third-party insurance to help guard against liability costs. And as I mentioned, the medical assistant can also invest in liability insurance if your provider does not have you already covered on the policy. Most of the time, you would be automatically covered under the office policy. On page 70, what constitutes a valid contract? So a valid legal contract has 4 essential elements: agreement, legality, competence, and consideration. So 2 parties have to have a mutual understanding and agreement on the intent of the contract. It needs to involve legal subject matter, legal capacity of both parties, and consideration. So those are the 4 essential elements that is needed for a valid contract. The provider-patient relationship is a contractual relationship, and it results in 3 steps. Provider invites an offer by establishing availability. The patient accepts the appointment, makes an offer by arriving for that appointment, and the provider accepts the patient's offer by examining the patient and beginning treatment. So that is all on page 70. Now, if you look at under number 3, there is something called, if the provider has accepted the patient, that would be an implied contract. They assume the provider will treat the patient using reasonable care. So it doesn't have to be a written contract, it can be implied as well. If you take a look on page 71, to protect to protect your provider against a lawsuit for abandonment, there are certain things that need to be covered for the provider when they are withdrawing from a case that needs to be involved in the patient's health record. To specify withdrawal of care, a letter needs to be sent to the patient, including a brief reason for the withdrawal of care, such as missing appointments or failure to comply with treatment. The letter states that the care is being discontinued as of a particular date, must have that information. The provider needs to supply copies of the patient's records to another provider upon request. And it should be advised that the patient seek the attention of another provider as soon as possible. Typically, this should be sent return receipt requested so that you have documentation that the patient received it, and that way you can hold on your dates for cutting off patient's treatment. Breach of contract occurs if there's failure to perform any term of the contract, whether it's written or oral, without a legal excuse. So if a plastic surgeon gives an estimate for services and it states the fee will be no more than $9,000, but then charges the patient over $10,000, that's a breach of contract. So usually you give them an estimate, not a firm amount, and that way your provider is covered. On page 71, medical professional liability lawsuit. They're far from rare. Every provider faces possibility of being sued, so they are there. You may have some involvement in preparing materials for court or scheduling depositions for the providers. Interrogatories, there are a list of questions from each party to the other in the lawsuit, so that would happen before the trial. The provider would be asked to complete that. A deposition is an oral testimony of a party or witness in a civil or criminal proceeding. This also would be taken before the trial. You may be asked to sit in on a deposition if you were involved in the patient's care as well. Subpoena, it's a document issued by a court requiring a person to be present at a specific time and place to testify as a witness, either in court proceeding or deposition. Subpoena duce tecum is a court order to produce identified documents or records. And that is usually something that is done in a malpractice suit. And you can charge a fee for the time spent in compiling those records, but it is something that needs to be handled immediately. If you are presented a subpoena for records, you do not want to delay obtaining those records for whichever party is asking for them. But before you respond to a subpoena on page 72, you want to make sure that, one, it is valid, because subpoenas can vary state to state. Subpoena issued in one state court generally is not valid for another state. So again, we want to verify that information. A subpoena issued by a federal court in one state is typically not valid in another state unless your federal statute authorizes nationwide service. Any duly authorized law officer can execute a valid subpoena anywhere in the same state. and the officer notifies the court once it has been served. The person or entity subpoenaed has 21 days to respond. But again, it's always best to get that information back as quickly as you can. And a subpoena duce tecum should be filed no less than 15 days before a trial. If it's less than 15 days, you should not be honoring it. You do want to check the subpoena, read it carefully, and only provide the information that they are requesting. Other information, you don't give them, just what they are requesting. Inside the courtroom, you'll have the plaintiff, the person or the group bringing the case to court, and the defendant, the opposite party or the respondent. Burden of proof. Criminal case, you have to prove guilt beyond a reasonable doubt. And in a civil case, it must be proven by a preponderance of the evidence. And the outcome of the case is what we call the verdict. Hopefully, you'll never have to be part of a liability lawsuit. But if you do, there is certain protocol that you would want to follow. Now, again, the medical liability and negligence. Before I go on to medical liability and negligence, got the mediation and arbitration at the bottom of page 72. So your mediation is a third party who helps those involved in a dispute solve their own problems. Is an alternative to a trial in which that third party, is chosen to hear evidence and make a decision about a case. So there are other steps before it goes to a full-blown court that can be tried. But again, it depends on the situation, what is being, what the issue is, and what the case is brought before the court. Liability and negligence. So when a patient is injured as a result of provider's negligence, they may initiate a malpractice lawsuit for financial damages. So this is where the medical professional liability insurance comes in. It is governed by the law of torts, and medical malpractice occurs when a provider treats a patient in a way that doesn't meet the expected medical standard of care as the community and provides harm to the patient. Negligence is a word you'll hear with regards to medical malpractice. Negligent implies inattention to one's duty or business or lack of necessary diligence or care. So this would be defined as the performance of an act that falls below the standards or behavior established by law. When there is a medical malpractice suit, typically there may be expert witnesses, which would be members of that same profession involved in that case, to provide their knowledge of possible treatment or what should take place. Professional negligence in medicine falls into one of the three categories: malfeasance, misfeasance, these are fun words, and nonfeasance. So malfeasance, intentionally doing something dishonest or illegal. So the surgical procedure for a higher insurance payment when they could have used a non-surgical method. Misfeasance, performing an act that is legal but not properly informed. So they do abdominal surgery that's indicated and necessary to help the patient recover, but they don't do it properly, and the patient has complications and passes on. Nonfeasance, failure to perform an act that should have been performed. So diagnostic findings indicate they have a tubal pregnancy, but the provider opts not to do surgery to take care of that. On page 73, the 4 Ds of negligence. So negligence is not presumed. It does need to be proven. And this is according to the American Medical Association. So they've determined that patients must present evidence of four elements before negligence can be proven. Duty. Duty exists when the provider relationship has been established. Dereliction refers to failure of the provider to perform his or her duty. There must be proof that somehow the provider neglected that. Direct cause, patient must prove the provider was aware of potential risk but did not inform the patient. And damages, physical, emotional, or financial harm caused by breach of duty. If all four of those elements exist, then the patient can be rewarded or obtain a judgment against the provider in that medical liability case. On page 74, you'll see some different types of damages: nominal, punitive, compensatory, general, and special. So nominal are small awards, token compensations, so small amounts of money. Punitive damages are designed to punish the party who committed the wrong in such a way as to deter repetition of the act. So sometimes that may involve a monetary figure of a much more significant amount. Compensatory damages designed to compensate for any actual damages caused by the negligent person. Um, General damages include compensation for pain and suffering, loss of bodily member or faculty, disfigurement, or other similar losses or injuries. And again, the fact of the losses has to be proven. Monetary amount does not. Special damages awarded for injuries or losses not necessarily a consequence of the provider's negligent act. So this can be loss of earnings, cost of travel. These both have to be proven. On page 74, risk management practices. Each facility should have a plan of risk management that covers patient-specific risk. These plans should include adequately trained providers and staff, open lines of communication, specific policies on how you handle expired prescriptions and refills, policies on patients' test results, how do you track missing appointments, communication issues with patients, making sure the facility is safe for patient use and employee use, and documentation procedures. All of these things can have consequences if they're not done properly. So we want to make sure that we have a process in place for all this information. On the bottom of 74, liability, malpractice, and personal injury insurances. Just to go over them briefly, the liability insurance protects healthcare facility if there's an accident at the facility that causes bodily injury or property damage. So if they fall in the parking lot, for example. The medical malpractice insurance protects the provider and or healthcare facility if there's a judgment against them for negligence, wrong, malpractice, anything like that. So most states do require that the providers carry malpractice insurance, and the amount of what they carry varies depending on their specialty. And then you have personal injury insurance, which covers bodily harm, non-physical, non-economic harm. So again, types of coverage depending on what is needed. So the provider has to have consent to treat the patient. Usually this consent is implied by the patient showing up for treatment, and that is sufficient for common or general procedures that involve little or no risk. But we always should ask the patient's permission on certain procedures, even taking vital signs, just to make sure we are covering ourselves. Expressed consent, sometimes known as general consent, is consent given after the patient is asked such a question. So, can I take your blood pressure? And they say yes. When we're doing more complex procedures, it should be informed consent, which typically means they are going to sign something after we provide a full explanation of the plan for treatment, complications, potential risks, side effects, anything like that. Typically should have them sign a form, sometimes have it witnessed if they have somebody there with them. In order to sign a consent, they do have to be mentally competent. It's invalid if the patient is unauthorized or if it's fraudulent. You can use implied consent in the case of an emergency. The Good Samaritan law is a form of consent. And for minors, consent needs to be obtained by the parent, guardian, or guardian ad litem, except again in the case of an emergency. And I mentioned the informed consent would include the patient's diagnosis if known, nature and purpose of the treatment or procedure, risk and benefits of the treatment and or procedure, alternative treatments or procedures, risk and benefits of those alternative methods as well, and what are the risk and benefits if they have no treatment whatsoever. Be aware of your state consent laws. Some states and insurance programs require a certain period to pass between the signing of the consent and the actual medical procedure. So, for example, with MaineCare, Medicaid, sometimes there's a 30-day wait period in the case of a tubal ligation. So they sign the consent, they have to wait 30 days, then they can have the procedure done. That gives them time, should they decide to change their mind. So again, giving consent to medical procedures, we want to make sure that is valid and that we have all the information we need to do that via the appropriate consent. If you look on the bottom of page 76, the exception to the need for a parental consent is if the patient is or the minor is an emancipated minor. This, again, does vary state to state, so be aware of your state laws for this. Typically younger than 18, and they have to meet one of the following conditions: married, in the armed forces, living separately and apart from parents or legal guardian, and self-supporting. So if they fall under that category, they do not need a parent's consent to have things done. Statute of limitations, period after which a lawsuit cannot be filed. So for malpractice issues, again, it varies from state to state, but it's typically 1 to 5 years. So if something happened to you in 2015 and your state gave you up to 5 years to file that malpractice suit, if you don't file by 2020, you would not be able to do that at that point. Confidentiality. This is one of the most important things. The patient is putting trust in you and the provider for their health information. In special cases, patient confidentiality plays a vital role. Obviously, we want to be careful with positive testing, who's given that information. There are certain tests that cannot be released under a regular medical record authorization. So again, being careful of that information, because we do not want to breach confidentiality. That's grounds for immediate dismissal. We need to use strict care when we're dealing with patient records and discussing information with those patients. The substance abuse, that is protected by federal statutes. So typically, that type of information would not be released when a patient signs a medical record release unless they are specifying that type of information. Compliance reporting. The provider is charged with safeguarding patient confidences within the restraints of the law. And again, according to state laws, those can vary across the nation. So we want to make sure we are compliant with the state that you are in. Births and deaths need to be reported, stillborns, gunshot wounds, knife injuries, poisonings, accidental suspicious deaths, sexually transmitted diseases are reportable in every state. Child abuse is reportable, and any other reportable diseases. So again, knowing what needs to be reported so that we do that. And local health departments do publish a list of reportable diseases and how to report them on their websites. And that would be very easy to obtain right over the internet or by contacting your state directly. On page 77, laws having a significant impact on care. There is what's called a Patient Self-Determination Act. This was brought about in 1990. It requires healthcare facilities to ensure patients receive information about, living wills, durable power of attorney, and advance directives. So again, that's why when you go to your primary care office, typically they will, and it might be on their questionnaire that they're handing out, but they will, if you have those advance directives, they are legal documents. They are for individuals to help make decisions about end of life care, or should they become incapacitated, somebody else has the capability for making medical decisions for them. How would you want your treatment? Being on life support, for example. Patients can exert their right to accept or refuse treatment when they complete an advance directive form. And these forms, again, are provided by healthcare facilities, hospitals, long-term care facilities, and you can always access them online. But again, it helps the patients make a decision with regards to cardiopulmonary resuscitation or defibrillator. Do they want to be resuscitated? Whether they want to be put on a ventilator, mechanical ventilator, or respirator? How long should artificial feeding be done? How long should dialysis be done? Antibiotics or antiviral medications can be used to treat infections, but a lot of people at the end stage of life develop pneumonia. So would that treatment be done aggressively or not done at all? Decisions about palliative care, organ and tissue donation, donating the body for scientific purposes. So when you complete an advance directive, the individual can also identify a medical durable power of attorney by proxy. And this would give a different person the opportunity to make those decisions for the patient. Again, we need to meet the state's requirements for the healthcare agent. It cannot be a doctor or part of your medical team. Has to be somebody willing to discuss medical care and end of life issues, be trusted to make decisions that follow your wishes and values, and be trusted to be an advocate on your behalf. And the advance directives, again, do need to be in writing, and each state has different forms that need to be filled out. If you look on the bottom of 78, Uniform Anatomical Gift Act, this was developed to make sure that all states have the same state laws about organ donation. The most important clause of this act permits the donation to be made by a written or witness document. This is considered a legal document in all 50 states. So they have to be a competent individual, 18 years or older. They can donate any part of their body after death for research, transplant, or tissue bank. They have to have a donor's valid statement of organ or tissue donation. when the autopsy is required by law by the family. The donor's family can give permission for organ or tissue donation after the individual passes. Providers who accept organs or tissues for transplants are protected from lawsuits. Time of death needs to be determined by a provider who is not part of the transplant team, and the donor may change his or her mind about tissue donation at any time. And typically, when this happens, if you look on the bottom of page 78, you will see a donor card, and that is something that typically you would carry with you to provide that information. The patient's Bill of Rights. It's more commonly known as the Patient Bill of Rights and not the Consumer Bill of Rights anymore. But there are 8 sections, and it lists 3 main goals. Strengthen consumer confidence by ensuring healthcare system is fair and responsive, reaffirm importance of a strong physician-patient relationship, and reaffirm the consumer's role in their care. So if you look on page 79, for the patient's Bill of Rights, it's information disclosure. So you have the right to determine who sees your healthcare information, who receives it, choice of providers and plans, access to emergency services, participation in your own treatment decisions, respect and non-discrimination, protecting that confidentiality of your health insurance information. Complaints and appeals, you have the right to a fair, fast, and objective review of any complaint. So if you were to request your medical records and you felt something in there was not documented properly, you have the right to file a complaint or appeal or ask the provider to relook at that. Maybe it was an error in what was said. And then consumer responsibilities, so protecting those consumer rights. Greater individual involvement by consumers in their care increases the likelihood of achieving better outcomes to support quality improvement and cost effectiveness. So again, that's there for all patients. If you look on page 80, Americans with Disability Acts, just touch briefly on this. The goal is to eliminate discrimination against individuals with disabilities. Individuals with disabilities must be able to enter and exit a facility without difficulty. They must be able to navigate through the facility without major barriers. So it has to be accessible for people with disabilities. So if you're up on the 3rd floor, there should be elevators. If you're on the 1st floor, it should have wheelchair accessibility or whatever it happens to be. Reach door handles for opening and closing, entering and exit building, moving through doors and hallways, drinking fountain, phones, restrooms, all need to be accessible. Moving from floor to floor, again, the elevator. Do everything the general public can do in a public place. Have access to communication devices if there's a problem with vision, hearing, reading, or comprehension. So again, just making sure we are providing that information. I mentioned the GINA Act, the Genetic Information Non-Discrimination Act. This is on the top of page 81, and this prohibits discrimination in health coverage and employment based on genetic information. So individuals cannot be denied health insurance, and employers make job-related decisions based on the individual's genetic history. So there is that act out there to help protect our patients as well. You'll probably hear HIPAA mentioned throughout the course, but HIPAA, know what it stands for: Health Insurance Portability and Accountability Act. It was signed into law in 1996. It sets standards, national standards for low health care plans, healthcare clearinghouses, healthcare providers, protecting the privacy of patient information. It had two provisions, Title I, which was the insurance reform, and Title II, which is the administration process. The goal of HIPAA was to limit administration costs of healthcare and privacy issues, to prevent fraud and abuse, provide security and confidentiality for patients. And again, I mentioned the two different provisions for this. Notice of privacy policies. It required healthcare providers to distribute a notice that provided a clear, user-friendly explanation of the protected personal health information rights. The law required the patient sign a acknowledgement that they had received the Notice of Privacy Practices, the NPP, and that needed to be filed in the patient records as well. Unless something changed, some offices have the patients re-sign on a yearly basis. A lot of practices, unless you make a change to that privacy policy, your patients do not need to continually re-sign. If you made a change to how you handled something, then the patients would need to re-sign. Requires healthcare providers to distribute that notice in a clear, user-friendly explanation of individual personal health information rights. And when it first came out, some of them were 8 to 10 pages long. They would give it to you, home, read it. Now, a lot of patients will just, as long as it's posted so that the patients have access to it, they don't need to take a copy if they don't want to. It would define how covered entities use individual identifiable health information, or again, the PHI. If you look on page 82, this is an example of a HIPAA acknowledgement. So it says, I was provided a copy of the national or the Notice of Privacy Practices. So you date it, sign it, put your date of birth. If you want caregivers or personal representatives to have information, it allows you to put that there as well. Request to receive confidential communications via cell phone, work number, email, whatever it happens to be. Following people not authorized to receive my patient health information. HIPAA requires a provider to take reasonable steps to limit the use. So again, what you can disclose, what you can't disclose. And then again, they put their name, signature, and date. Some definitions of HIPAA terms. Covered transaction. This is a transaction covered under the regulations of HIPAA that involves the processing of healthcare claims, such as requesting payment from the insurance carrier, a request for patient referrals from a provider, any electronic communication about their healthcare claim status, the enrollment or termination of a healthcare coverage. This is also termed a transaction. Minimum necessary standard requires cover entities to take reasonable steps to limit unnecessary access to that protected health information. So again, limiting what information is going where. States preemption of HIPAA. The HIPAA privacy provides federal privacy protections for the protected health information for covered entities or business associates. But it does, again, we mentioned it earlier, require reporting those reportable diseases or injuries or child abuse or shootings, gunshot wounds, knife wounds. TPO, HIPAA permits use and disclosure of pertinent health information for treatment, payment, and healthcare operations. So the payment includes billing and collection activities, healthcare operations, and business activities. So as a medical assistant, you need to be aware of the rights of the individual patients regarding their pertinent health information. They do have a right to access their own personal health information. They can request changes or amendments be made to that personal health information. They have the right to be notified when you are sending their records somewhere or when somebody is requesting those records. They have the right to know who the covered entity shared their pertinent health information or protected health information with and what was disclosed. So if a patient came to you and said, for the last year, I want to know who you sent my records to, you would have to provide that information for the patient. They have the right to request restrictions on the use of that protected health information. The HIPAA security rule on page 83, this covers use and transmission of electronic protected health information. It requires three types of safeguard: administration safeguard, physical safeguard, and technical. So the administrative is actions, policies, and procedures put in place to maintain security measures. The physical, actions, policies, procedures taken to protect the covered entity's electronic information. And the technical, the use of technology to secure that protected health information and limiting the access. Excuse me, I think I got to sneeze. Covered entities must also have in place procedures for obtaining that electronic protected health information in case of an emergency, natural disaster, for example. The security rule recommends automatic log off to prevent unauthorized access. Anyone can file a health information privacy complaint through the complaint portal for the Office of Civil Rights. The complaint does need to be filed in writing, by mail, fax, or email. The name of the covered entity, who's involved, and the act needs to be described for which the HIPAA regulation was violated. So patients, anybody can do that information or file that. Again, if you look on page 84, this goes over what I just went over, but gives the patients the right, defines the rules that covered entities need to follow to discuss the patient's health records, the safeguarding of that personal health information, how to use access limits for that information as well. And again, HIPAA, the benefits were to lower the administrative cost, increase data accuracy, increase consumer patient satisfaction, reduced revenue cycle time, and help to improve the financial management for the providers. Now you can see on page 85, there's an example of a patient consent for the disclosure of their protected health information. So here it gives the information, who they can release the information to, that they can revoke it at any time. I have the right to request a list of my disclosures, and then obviously the patient's information and signature. On the bottom of page 85, the High Tech Act, Health Information Technology for Economic and Clinical Health Act. This was signed into place in 2009. It was to promote adoption and meaningful use of health information technology. Physicians who did not adopt electronic medical records when this went into effect would be penalized by Medicare in the way of payments. So their payments would be dinged a percentage if they did not conform with this particular act. So there were non-compliance penalties. Data breach notification requirements. It required the Department of Health and Human Services to conduct periodic audits for covered entities and business associates. And there were mandatory penalties that were imposed for willful neglect of this high tech under HIPAA. You, as a medical assistant, if you do not comply with the High Tech Act, you also can be fined. So, again, knowing what's out there for rules and regulations, so we make sure to follow them so we don't run into issues. On page 86, Affordable Care Act of 2010, it was designed to provide better health security by enacting comprehensive health insurance reforms that hold the insurance companies accountable, lowering healthcare costs, guaranteeing more choices, and enhancing the quality of care for all Americans or all patients. And you can see on page 86, this started in 2010. 2011, they made changes to Medicare, free preventative service, 50% discount on brand name drugs, increased access to services for disabled individuals through Medicaid. 2012, established accountable care organizations and other programs to help providers to deliver better care. 2013, open enrollment on the healthcare marketplace. 2014, tax credits for middle, low income families that covered hopefully a significant portion of the cost of health care. They expanded the Medicaid program. And 2015, modified provider payments. So practitioners who provide higher value care got higher payments. So on the bottom of 86, in closing, most patients usually don't think about taking legal actions against a provider unless something really serious happens. So we just want to be aware that we are following protocol, using discretion when we're talking to patients or when we're discussing patient information on the phone or in the hallways, whatever it happens to be, keeping accurate records so that we have anything we need to support what we've done. Only perform the tasks that you're trained at. If you're not trained, you don't want to do something that you're not trained at because that's when it could run into issues. Don't be skeptical. Assistance prevent claims. Practice patience. Make sure you stay up to date on regulation changes. Stay calm. Answer all the patient's questions. Again, the most important detail is patient education and the law. So be patient with this information. Patients can become frustrated with the number of changes that they have to deal with. And we just need to remain calm and answer the questions to the best of our ability or get them answers to their questions if we cannot answer it. The legal and ethical issues. Generally, the law holds every person liable for consequences of his or her own negligence. So you are liable for your own negligence. Providers, physicians are responsible for their employees. Physicians are responsible for their partners. And unfortunately, injured patients can sue physicians. And if that happens, you as the assistant could be liable or at fault. So as long as we are being professional, be aware of your actions that you're taking and adhere to the laws for the healthcare practice, you typically should be all set. So again, the law is a long chapter, but again, just being aware of what's out there. And as long as you are performing your duties legally, ethically, you should be all set. Again, no class next week. The following week, December 2nd, we will again cover chapter 7, which is medicine and ethics, and technology and written communication, chapter 8. if you do have any questions again as you're going through your workbook, please feel free to email Jamie, Amy, or myself, KJ, the number 3, BOYS at yahoo.com. I will be away next week, so unfortunately, I don't have access to answer questions next week. But if you do email me, I will make sure I address them as soon as I'm back if it's something that can wait. If not, then please get directly in touch with Jamie or Amy. So thank you very much, and I will see you in a couple of weeks, and I hope everyone has a wonderful Thanksgiving.